but I also went back through Judge Fox's docket and in CV 2024-091179, and I reviewed his ruling, lengthy ruling on the motion for protective order and his later July 31st minute entry on the related deposition dispute. So I'm familiar with your positions and what's occurred in the other case, but I want to give you both an opportunity to talk to me about the issue as far as this case is concerned. I will tell you that generally I don't force parties to take remote depositions. When an attorney wants to take a deposition in person, it would take a lot for me to override that and force an attorney to take a deposition in remotely, regardless of the other circumstances. So that's something that I generally don't do in the absence of a really significant reason to do so. I recognize that there are some complicating factors in this case that are unusual, but in going through Judge Fox's ruling, I really don't see any big differences for this case, particularly because he's already issued the order that the deposition has to take place in person in Maricopa County. What difference it would make to also require on the same day, to avoid any inconvenience, the deposition occur in this case of the same party in person. So those are really the things I'd like you to focus on, but I'll hear you out on anything else that you want to add or any updates or changes that have happened since you filed your joint statement. So why don't I start with Mr. Summers, because you're really the one seeking relief here.
Thank you, Your Honor. Did the court look at Judge Thorson's ruling in CV 2024-090203?
I didn't see that was, is that something that I did
only
not.
I only raised it in an email in response to the notice of Judge Fox's ruling. In that case, Judge Thorson.
You know what, but before you go forward, can you give me the case number again?
Sure, it's CV 2024-090203. And it's an order from July 22nd, 2024. And the issue was similar. It was Bell Bank was defending against Carolina Lopez and Mr. Kirkland. And they asked for Mr. Kirkland's deposition to be in person. And the court ruled that they had to take his deposition via remote means. And the issue there is the exact same as it was in Judge Fox's case. And obviously the court ruled that they can be deposed remotely. Now, the main difference between that case and Judge Fox's case and this case is that Mr. Kirkland is a defendant in this case. And the law regarding compelling parties to appear in a forum is much different when it's a plaintiff versus a defendant. And I'd also like to point...
He's not just a defendant, though, in this case. He's also a third-party plaintiff.
In this case, he's a third-party plaintiff against Kylie Griffith and Maury's Leasing, not against Kea State Bank.
Okay.
And so, as a defendant, if you look at Rogers versus Fenton, 115 Arizona 217, Court of Appeals 1977, it says, quote, a party is not entitled as a matter of right to depose another party on oral examination at the situs of the forum. It has been held that although a plaintiff can designate any place for the taking of a deposition, it is presumed that the defendant will be examined at his residence or place of business or employment. And if another place is named, the defendant files a timely objection, it should be sustained absent some unusual circumstances to justify putting the defendant to such an inconvenience. Well,
right, but aren't the unusual circumstances, I apologize for interrupting, but aren't the unusual circumstances that, we're not talking about a deposition in a town a couple of hours away. We're talking about requiring either the deposition be taken by remote means, which is not the same as taking testimony in person. After COVID and years of going through virtual versus in person, I can tell you that there's a reason the Supreme Court order says testimony and evidence should be taken in person as opposed to hearings like this to be done virtually. And also, so the alternative is to require everybody to travel to an unknown place in Europe, right?
Right, Your Honor. If they really wanted it to be in person, which, this whole thing is a ruse, Your Honor. They have no intention of taking Mr. Kirkland's deposition testimony under any circumstances. The reason why they even filed or served the notice of deposition was to try to compel him to come to either be arrested or to have to be sanctioned for not appearing. That is the reason why they're sending these notices of deposition. In this case, I sent the notice of deposition first, asking for the remote deposition. I should have the opportunity to make my case for why Ms. Lopez should be allowed to preserve Mr. Kirkland's testimony for trial in a deposition taken via remote means. I don't know why we're even talking about compelling an in-person deposition of a defendant who not only lives in Europe, but does not have a U.S. passport. He literally cannot board an airplane to come to Arizona, even if he wanted to turn himself in. And he would have to go ask the court in Washington for permission to get a passport. And this whole thing is just a gotcha game of trying to take a defendant and say, you know what, I'm going to somehow find a way to sanction you for not, basically surrendering your liberty, for not giving up your fugitive status and coming to be deposed in this lawsuit. And that's exactly what fugitive disentitlement starts to get into, that you can't just simply hold someone's fugitive status against them where there's other means to get their testimony, to conduct discovery in a reasonable way. And in this case, we've got a pending summary judgment motion where the bank, in our opinion, is going to lose. And the only way they're going to try to salvage some sort of, victory here is to get some unreasonable sanctions against Mr. Kirkland to get some sort of judgment against him. I'm not even sure that the bank has thought through whether or not the sanctions they think they're going to ask for are even justified for not appearing at an in-person deposition. The only reasonable means of taking Mr. Kirkland's testimony, if that's really what they want, if they really want his testimony, is to take a remote deposition. They complain about potential pitfalls like, people are going to somehow coach the witness or cheat or something like that. But, there's a case in the federal court where they said, why don't they just take the deposition first and then tell us if there was problems with it, So I think this whole thing is just a ruse. It's just a trap. They're just trying to set a procedural trap for somebody knowing they've got this problem. And it's no different than if Mr. Kirkland was an astronaut on the space station. He's not accessible, but it would take a lot of effort and force to get him to come back down from the space station. And instead, if he was an astronaut on the space station, I guarantee you they would allow the remote deposition. But Mr. Kirkland's actually being punished for being a fugitive, and that's exactly what the fugitive disentitlement doctrine militates against. So I think it's very different that he was a plaintiff in the other cases. He's a defendant in this case. It totally changes the analysis. Judge Fox's ruling is completely irrelevant to this case. It is simply not based on the same factors of a defendant versus a plaintiff. And I'll also point out to the court that Mr. Kirkland has asked to be dismissed as a plaintiff, which is actually a cross-claimant in the KS State Bank case. And he's asked to be dismissed. He's actually filed a motion to dismiss himself as a plaintiff in the federal court case. So to the extent that the plaintiff in this case says, oh, well, Mr. Kirkland's tried to avail himself of the forum, he was a defendant who filed a counterclaim, but basically a cross-claim. And then in the other case, he's moved to dismiss himself as a party. So he is not trying to avail himself of these forums for any purposes. He's simply trying to defend this litigation and is being, drawn into some sort of discovery trap to try to get sanctions against him rather than actually take his testimony.
Thank you, Mr. Summers. Mr. Sritarana?
Thank you, Your Honor. Can you hear me okay?
I can.
All right. So I guess I want to give a little bit more context, and then I'll address some of the points that Your Honor raised at the outset and also that Mr. Summers just raised. As we noted, and as perhaps the court would note in reading Judge Fox's ruling, The defendant's primary defense in this case is the primary disputed issue in the Green Home case. And it relates to whether there was this forbearance agreement that was all encompassing between Ms. Lopez on the one hand and the bank on the other that covered all the borrowing entities in which Ms. Lopez had an interest or for which she guaranteed a debt owed to the bank. And Ms. Lopez and the defendants in this case contend that the alleged forbearance agreement precluded the bank from exercising its remedies to collect a debt owed by Slate Rock and Gravel and its guarantors, including Mr. Kirkland. So the forbearance issue also ties to a course of dealing and performance argument that they've made in the other case, essentially that the bank had a course of dealing with Mr. Kirkland while he was in control of these entities and the primary bank contact to casually allow defaults to be cured. But this puts Mr. Kirkland in the middle of the factual dispute in both cases. So in short, he's a material witness, number 1A or number 1B with Ms. Lopez in both cases, regardless of his party status. And as the court correctly noted, he is